Greetings and welcome to this week's edition of Smart Counsel for Lunch. I'm Suzanne Sayward, a partner at the Dedham, Massachusetts law firm of Samuel, Sayward, and Baylor, where we concentrate our practice in the areas of estate planning, elder law, estate and trust administration, and probate. Today, I want to talk a little bit about the terminology associated with trusts. Lawyers, just like many other professions and industries, often have their own language that makes sense only to them. Sometimes we fail to fully explain things to our clients because we are so used to tossing these terms around. But of course, it's important to understand the various terminology when you're working with these documents. So a trust, for example, is a relationship between three people: the person who creates the trust, the trustee, and the beneficiary. The person who creates the trust is sometimes referred to as the grantor, or maybe the donor, the settlor, the trust maker, or the trustor. Any of those terms are often used to identify the person who has created the trust. The trustee is the person who is in charge of managing the assets in the trust. So the grantor entrusts the trustee with whatever assets the grantor wants held by the trustee. And the job of the trustee is to manage those assets for the beneficiary, who is the third party in this relationship. The rights of the beneficiary are determined by the grantor when the trust is created. Is the beneficiary entitled to receive all of the income generated by the assets in the trust? Is the beneficiary entitled to any of the principal? Who decides that? These decisions are made by the grantor when the trust is created. If we can help you answer any questions about using trusts and whether they would be valuable to your planning, please don't hesitate to reach out. And before you leave us today, please make sure you subscribe to our channel and like our video. And we'll see you back here in this space next week.